Welcome to U Counsel. Each couple may decide to marry or live in a common law relationship based on their personal preferences and personal beliefs, but the law may treat each couple differently based on the nature of their relationship, and in this lecture we will explain the commonalities and differences between a married couple and a common law couple. We begin with our usual disclaimer that this lecture is not legal advice. So if you have any specific questions, you should contact a lawyer or a paralegal or the Law Society of Ontario for a referral. Married versus common law partners. What are some of the rights that are same? Number 1, child custody. Number 2, child access. And number 3, child support. It does not matter whether you're married or you're common law. As long as you have children together, the custody, access, and support issues are dealt with in the same manner. Makes no difference. Now, the applicable law with respect to custody and access and child support may be different. For married couple, they have a choice of choosing between federal laws or provincial laws, but with respect to common law partners, the only law that applies to their circumstances is the provincial law, and one of our previous lectures explains that. What are some of the rights that are different? Number 1, property and debt. For married couple, they share the value in all of the property and debt, and this process is called equalization payment. There is a whole formula for this. We will explain that in the future lectures. So all of the debts, all of the property, and property is not just the house. Property could be anything: car, furniture, computer, any assets that you may have, those are all considered property. And similarly, debt doesn't have to be, it doesn't matter whether one partner has a credit card debt and the other doesn't. It does not matter. All of the property and debt is sort of pooled together, and that's where the share of the value between the two partners, married couple, is decided. Now, that could be different in circumstance where there is an agreement between the married couple, which could be a marriage agreement or cohabitation agreement, and as long as that agreement does not violate statutory rights, then that agreement will be enforced. Now, with respect to common law, the principle is pretty much straightforward. To each its own. If you own a property in your name, that's yours to keep, and the other partner has no rights in that property. Now, and then again, if the property is owned jointly, then of course the law will apply, and then the rights will be based upon your share in that property. And same applies to debt. If the debts have been accumulated separately, then the person who has that debt is liable, the other partner is not. The property and debt, even if a common law couple is living in a rental apartment, if only one person has the name on the lease, then that person will have the right to stay in that apartment and the other person will not. So the application of the law is pretty straightforward with respect to common law couples. Another place where the rights would be different is family home, also called matrimonial home. Married couples have equal rights to stay in the family home and then have the right to claim the share in the value, again, equalization payment. That is the entitlement for a married couple. But for common law, again, to each its own. If you don't have the share in that property, if it's not joint, then the person who owns that family home is the person who will keep it. Another kind of right which is different is inheritance. If a married partner dies without a will, then there are specific rules which will automatically entitle the surviving married partner to certain rights. That is not the case in common laws. There is no automatic right of inheritance if a common law partner dies without a will. So it's an important distinction to note. Now, there are circumstances in which the surviving partner, common law partner, may be able to claim certain rights and inheritance. But again, it's a complicated area. It's hard to prove, but it can be done. The point is it can be done in certain circumstances. But what you want to remember is that there is no automatic right to inheritance when the partner has died without a will. Now, there are some rights that can be same. It depends upon the circumstances of common law partner, and the rights could be the same. Number 1 is spousal support. As we know, married couple can claim spousal support either directly or through a court. Now, common law partner can claim spousal support only if they have lived together as a couple for at least 3 years. That's in the province of Ontario. I believe the other provinces may have different time periods for staying together, but in Ontario, 3 years. If you have lived for 3 years, only then you can claim spousal support, otherwise not. Or the common law partner were in a relationship of some permanence for any length of time and had a child together. So if you had a child together and the nature of relationship was of some permanence, regardless of the time period, then you may claim spousal entitlement. Now, with respect to spousal entitlement, one point that you want to remember is that once a common law partner is entitled to spousal support based on these conditions, then the duration of spousal support or the amount of spousal support does not differ. So it's not a scenario where if a married couple is entitled to spousal support, he or she will get more money and then the common law would get less, or vice versa. No, that makes no difference. As long as a partner can qualify, then length and time period has its own rules, and it doesn't matter whether you're married or common law. Welfare and disability benefits can also be same depending upon the circumstances. If a couple is married, then if they're applying for assistance or disability benefits, their combined income is considered in deciding what is the assistance that they will receive. In common law, their combined income is considered only if they have lived together for at least 3 months, not 3 years, 3 months. They have shared finances and lived in a marriage-like relationship. Immigration sponsorship, as we know, a married person can sponsor the other married partner to come and become a Canadian citizen. Common law partners can sponsor only if they have lived together for at least 1 year, or they can prove that they were conjugal partners. And conjugal partners is a specific term, and it will be interpreted according to the immigration statutes that apply. With respect to healthcare decisions, if there is no power of attorney for personal care, then a married partner is the substitute decision maker for the other partner who does not have the capacity to make his or her own decision. So in those circumstances, the married partner is the substitute decision maker. In common law partnership relationship, absent a power of attorney for personal care, the common law partner is a substitute decision maker only if they have lived together for at least 1 year, or have a cohabitation agreement, or have a child together. So in one of these scenarios, the common law partner will be the substitute decision maker when there is no power of attorney. So what you want to carry from this lecture is that it is important, whether you want to marry or not, it is important for you to understand the legal implications of each kind of relationship, and so that you know how the law will treat your relationship if you ever have a situation that you have to rely on the legal framework. Thank you for watching.